Hello ladies and gentlemen, and welcome to Semple Fraser's podcast on companies, directors and officers' health and safety responsibilities. My name is Caroline Stevenson. I am a corporate solicitor and I'm joined today by Charlotte Johns, an employment director. We are both part of Semple Fraser's renewable and energy group. As a group, we are involved in a wide range of projects covering all sectors, from hydro, wave and tidal, solar PV, AD, energy from waste, clean coal to onshore wind projects, of which we have around 850 megawatts of projects underway at present. Today we will be covering the issue of health and safety in the context of renewable energy and will concentrate on identifying the issues and the relevant legislation. We'll be explaining who can be liable and clarifying which measures should be put in place to prevent or at least minimise breaches. The UK energy mix is changing from a landscape dependent on fossil fuels and a system of centralised generation to a structure where new and old technologies work alongside each other and generation is increasingly more widespread. The pace of the industry is rapid, and as more technologies enter the market, more health and safety hazards are evolving. Ensuring that these health and safety issues are addressed will promote confidence in the sector, not only from the public, but also from investors and employees. People will be more inclined to get involved with the sector if the hazards involved are, if not low, at least managed. The public will be less inclined to protest against developments in their area if their safety is well addressed, and investors will be more willing to invest in technologies or developments where their potential exposure to risk is reduced. As with any industry, the health and safety hazards can be broken down into three main categories: major hazards, occupational hazards, and hazards to the public. Major hazards, as you would imagine, have the biggest impact on the public. They have the potential to have repercussions outside the immediate vicinity of the incident and can result in numerous fatalities. A recent example of a major incident is the explosion on the Deepwater Horizon oil rig in the Gulf of Mexico, which resulted in the death of 11 people and caused the largest offshore oil spill in US history. In a renewable technology sense, an example of a potential major hazard could be the collapse of an offshore working platform during turbine construction or maintenance. Occupational hazards present themselves to employees within an organisation and are lower level hazards than major hazards. In a renewable sense, this could be exposure to hazardous substances during the manufacture of wind turbines or solar panels, or falls during the construction or maintenance phases. Renewable technologies can also pose hazards to the general public. Although the public can also be covered by major hazards, due to the more localised nature of implementation of many technologies these days, such as microgeneration wind and solar in built-up areas, the proximity between the technology and the public inherently creates risks. Blade throw or turbine collapse are both examples of hazards to the public, although depending on the severity of these, it may be that they are also classed as major hazards. As you can see, through the novelty of these technologies and their situation in relation to the public, more and more hazards and risks are being created and identified, which of course has consequences for those involved in the industry. Employers, officers, directors and companies themselves can all be held accountable for breaches of health and safety and have responsibility to safeguard against these risks through a number of different legislation. Charlotte will now cover the applicable legislation and employers' liability.
Thanks, Caroline. Liability can arise in a number of different ways, which will be explored in more detail in the coming slides. In particular, we will look at the Health and Safety at Work Act 1974, which sets out general duties employers have to employees and the public, the Corporate Manslaughter and Corporate Homicide Act 2007, which imposes liability on a corporation if the gross breach of a company's duty of care causes a person's death, and we will also look at the Companies Act 2006, which imposes general duties on directors and officers of a company, as well as the common law offences that apply. The Health and Safety at Work Act sets out generic, high-level requirements for health and safety that apply to all employers. Under the Act, employers are required to do what is reasonably practicable to ensure health and safety. The government, in conjunction with the Health and Safety Executive, has also issued numerous regulations which provide more detailed guidance on what is required. Some of the regulations are goal-setting, whereas others are absolute. Some regulations apply across all industries, whereas others will only apply to certain areas. The Health and Safety Executive has also issued various items of guidance which set out industry-specific and technical advice. Finally, the Health and Safety Executive has also issued various approved codes of practice. The codes of practice are not themselves enshrined in law, however they do have a special legal status in that they will be taken into account by the courts when considering any health and safety prosecution. One of the most important regulations is the Management of Health and Safety at Work Regulations 1999, which are usually referred to as the Management Regulations. These provide much more explicit guidance as to what is expected from employers. In particular, all employers are required to carry out a risk assessment, and if they have more than 5 employees, then they must formally record the findings of the risk assessment. In addition, all employers must make arrangements to implement any changes identified as being required under the risk assessment. The employer must also appoint a competent person or persons who will be responsible for health and safety within their organisation. The competent person may be an employee or an external consultant. Depending on the complexity of the organisation, the competent person may be somebody who operates at a very senior level, potentially sitting on the board. The competent person may delegate some of their duties to recognised experts. However, the competent person remains responsible for the overall health and safety compliance within the organisation. Under the management regulations, an employer must also set up appropriate emergency procedures and provide health and safety information and training to its employees. Separate regulations also provide that all employers must display a poster telling employees what they need to know about health and safety, or alternatively provide all employees with an appropriate leaflet. Employers should also be aware that under RIDDOR, certain accidents and injuries must be reported to the Health and Safety Executive. Finally, the majority of employers will be well aware of their legal obligation to put in place appropriate insurance. It is absolutely crucial that employers familiarise themselves not only with the management regulations and other regulations that apply across industry as a whole, but also with the various industry-specific regulations that will apply within their particular field. Employers should also keep an eye out for industry guidance and specifically monitor developments within their industry. Within the renewables sector, best practice is constantly changing and developing, and it is important to keep up to speed with any practical issues that other employers experience within your field in order to review your own practices accordingly. You may, for example, decide to sign up for free updates and bulletins from the Health and Safety Executive. Renewables UK is also a good source of health and safety information for the renewables sector. It is also crucial that organisations consider whether their competent person is qualified to an appropriate level. The greater the complexity of your operation and the wider the number of industry-specific regulations that are likely to apply, then the more likely it will be that you require somebody who is highly specialised and qualified within the area of health and safety. It may be that a senior manager or director within the organisation takes on primary responsibility for this role, but if health and safety is not their first area of expertise, then they will need to consider appointing someone else either internally or externally with the appropriate expertise. It is absolutely crucial that the health and safety agenda is given top-level priority.
Carrying on from what Charlotte said, it's important to note that the Health and Safety at Work Act 1974 also imposes individual liability on directors, company secretaries, or managers of companies. These officers can be held personally criminally liable for offences where the relevant company is found guilty of a health and safety offence and the offence was committed with the consent or connivance of or was attributable to any neglect on the part of the relevant officer. Consent means knowledge or awareness of the circumstances and the risks which caused the failure. Connivance means knowing and not doing anything about the risks, and neglect means unreasonably breaching a duty of care. Directors prosecuted under Section 37 of the Act can be liable for fines, imprisonment, or can be subject to a disqualification order preventing them from acting as a director for up to 15 years. For example, in January this year, a construction company and director were fined following the death of a young worker named Mr. Page at a site in Hampstead. The Health and Safety Executive Inspector stated, and I quote, "From the start of this project, the defendants failed to control even the most basic of risks on the construction site. These failings ultimately resulted in the tragic and entirely avoidable death of Mr. Page." In addition to this, company officers can also be charged under the common law crime known as manslaughter in England and Wales and culpable homicide in Scotland. An officer commits this crime where he owes a duty of care towards an individual, and as a result of a breach of this duty, the individual dies. The court must be satisfied that the individual died through the gross negligence of the officer, to the extent that the officer had an obvious disregard for the deceased's life. As you can see, the test is quite high, and as such, prosecutions are rare. That said, successful prosecutions have been on the increase. For example, in July 2004, the managing director of Nationwide Heating Systems was convicted of manslaughter and sentenced to 12 months imprisonment. Officers guilty of this common law offence will be punished by a term in prison as determined by the relevant judge. The Corporate Manslaughter and Corporate Homicide Act 2007 applies to all companies and other corporate bodies operating in the UK, whether or not those companies were incorporated in the UK, and it applies to both the public and private sectors. It also applies to partnerships, to trade unions and employers' associations if they are an employer, as well as to government departments and police forces. The offence under the Act is concerned with the corporate liability of the organisation itself and does not apply to individual directors, senior managers or other individuals. Nor is it possible to convict an individual of assisting or encouraging the offence. The Act requires that there has been a gross breach of the relevant duty of care by the organisation to the deceased. The Act states that there is a gross breach of duty if, and I quote again, "conduct alleged to amount to a breach of that duty falls far below what can reasonably be expected of the organisation in the circumstances." The duty extends to employees or other workers, occupiers of premises, or others connected with the company through supply arrangements. Organisations found guilty of an offence under this Act can be liable to a fine, a remediation order, and/or a publicity order. An example of this occurred in February last year, where Cotswold Geotechnical was fined £385,000 after being found guilty in the first ever corporate manslaughter prosecution.
Caroline, that's a position that no company wants to find itself in, I think. Turning to have a look at risk management now. Understanding the legal requirements and putting in place appropriate systems is absolutely key, not only to protect the welfare and health and safety of employees and members of the public, but also for the protection of the officers themselves. In emerging technologies, however, identifying potential hazards and risk is not straightforward. New technologies traditionally have a lack of safety data available, in addition to which, in some cases, the potential hazards have not come to light as yet. This, coupled with the fact that many involved are new to the sector and in some instances could be inexperienced on the proper implementation or maintenance of technologies, can result in errors due to lack of skills. Nevertheless, those involved with the sector have a duty to protect the safety of their employees and the public at large. As such, it is important that health and safety is implemented early in the development stage. Keeping health and safety at the forefront of the mind promotes compliance rather than thinking about the issues retrospectively. Those involved in the renewables sector should make every effort to clearly identify the hazards and risks in their area and to provide for these in concise health and safety policies that should be available to all involved.
So what should companies do? Well, companies should ensure that they have good corporate governance procedures in place. In reality, this starts with the recruitment process to ensure they get the right people. It extends to their training and development programme and through to decision-making and reporting procedures. At a board level, it is essential that officers are receiving information which is as accurate and up-to-date as possible and focuses on the key things rather than the key things being lost in a mass of corporate jargon and puff. Reports must be produced timely and must be read in a considered manner. As Charlotte mentioned earlier, there must be clear reporting lines and it must be clear who is ultimately responsible for areas of risk. Boards should be encouraged to meet regularly to be kept informed of their company's health and safety risks and performance. It may also be helpful to formally appoint a health and safety director to have direct responsibility for reporting on these matters. Finally, it may be appropriate for companies to have insurance and cover in place for their directors and officers. Indeed, it is considered part of good corporate governance practice to have such insurance, and in fact, the combined code requires it. The ability to provide such insurance is also specifically permitted by the Companies Act. Directors and officers' insurance must provide cover for the right people, the right risks, and with the right level of cover. This might seem to be stating the obvious, but for example, the directors of Equitable Life were rumoured to have cover of £5 million and were in fact sued for £1.7 billion. As you can see, as if directors and officers did not have enough duties to consider like those inherent in the Companies Act 2006, they also have to bear in mind the relevant health and safety legislation as well. Given the increase in deployment of renewable technologies, unfortunately we see it as only a matter of time before a renewables-focused health and safety claim comes to light. There is light at the end of the tunnel, however. If you implement the measures we've suggested and ensure you take relevant advice, any risks and exposure can be mitigated. On behalf of Charlotte and myself, I'd like to thank you for your time. We really hope you find this podcast useful. If there are any issues or questions you would like to discuss, please do not hesitate to contact either Charlotte or myself. You'll find our contact details on the last slide.